to upper 30s with that frost advisory in the shoals. Heading into the afternoon, though, we do rebound nicely. We'll be in the low 60s, and we'll have a gradual warm-up trend heading into the rest of the week. By Wednesday, we're back into the low 70s.
I like where we're going there, at least for the highs of the week.
Yeah, and then next week, we're just going to ignore it for now.
That's right. We'll let that go. Thanks, Lainey. Thanks for watching WAAY 31 News at 10. Stay right where you are. WAAY 31 Law Call is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call, the only live legal call-in show in the Tennessee Valley. You call, we answer. That's the way it works here. I'm Robert Lane, sitting in for Sharon Doviet. Well, it's Halloween. We're going to talk a little Halloween today, but our topic is Ask Us Anything. Anything about the law, that is. And with me, here's how it works. You call 256-536-0077. You can either call or you can text, and you will get Michael Timberlake of Timberlake, League and Brooks.
Well, it's great to be here, as always.
I always say Michael is the smartest lawyer I know, and he hates it when I say that, but I actually have a question this time.
Okay.
Let's say a parent who wants their kid to be in law school.
Right.
Just how smart do you have to be a lawyer?
It just depends on how good of a lawyer you want to be. I'm not going to throw some people under the bus, but
good grades in high school?
Well, I think basically what you look at is if you're interested in law school, if you're somebody that is interested in, has the ability to communicate, either both verbally and written, and has the ability to think logically and reason, argue. I raised one of those. My other kid doesn't like to argue. I don't think he'd be a very good lawyer. But those are the kind of things that, in general, you look at when you in terms of lawyers. But there's all kinds of kids that go to law school that do all kinds of different things. So I think mainly, just focus on, making, good grades, writing, communication skills are very important.
Now, we have, we're getting your phone calls in, you call, you have a comment on something about the law, we'll take all of that tonight. But we have some video to show, and you make the law call.
Yeah, I always love these. I never watch them ahead of time.
Well, here is the question for you. So, the neighbor called you over, okay, says, I got a bunch of pumpkins. Let's do some pumpkin chunkin' here.
Yep. There's beer involved, I'm sure.
And just watch, and... So, Michael, who's paying those medical bills? The neighbor or the guy who did it?
Well, basically, if you invite somebody over to your house and you have a dangerous condition on your property, then you have an obligation to warn the person that even if it's a social guest, but if it's a condition that you know is dangerous, you have an obligation to warn them about the known dangers. But in every situation involving premises or homeowner's liability, there are defenses that they can present. And one of the defenses is if the hazard or the defect or the condition on the property is open and obvious, so that any normal person would understand that it is, creates a danger and could injure somebody, then they're not responsible for an open and obvious condition. The other thing that you got is if somebody assumes the risk of injury, and by that they have to engage in an activity where they realize and should have realized that it presents a danger to them. They have to appreciate the danger. If they engage in that activity knowingly, then the homeowner wouldn't be liable. So I think it's a bad injury for sure, but I think there's some defenses there.
And there's some damaged pumpkins in
your
yard.
It's a lot of damaged goods.
Okay, Michael from Athens has been very patient and standing by. Michael, what's on your mind tonight?
Well, I've been living in the same place for almost 40 years, and I built a garage by somebody's mother said I could build it there. Then now that they've had it surveyed, my property is over their property, and they've done a survey and said I can't mow where I've been mowing for 35 years.
Yeah, I mean, so basically, if you're looking at a situation where you're talking about a property line here, if there is a, if there's a situation where you're what you're doing on somebody else's property has been what we call open, which means everybody knows that it's there. And two, it's adverse. And that means that they either have told you not to do it or they have not given you permission to do it. It's not something they say, hey, you can do this, that's fine. You can cut the grass over here, I appreciate it. If it is open to them and adverse, which means they've told you not to do it and you do it anyway, and you can prove that it's been that way for a period of, I think it's 21 years in Alabama for adverse possession, then you can contend that you actually own that property. So if it's a situation where you're trying to claim ownership of a certain piece of property, that's one thing. If you are just trying to get access to that over that property, it could be an easement, trying to use that piece of property for your own good. They can probably prevent that unless your property is landlocked. You can call in Alabama we support an easement by necessity, which means that if your property is landlocked and the only way is through another piece of property, then you can typically get access to your property. So difficult situation.
Okay, well, I got another property question, but this one, I think they changed the facts a little bit.
All
so
right.
They said, well, if I'm renting a property and I'm going to give them a bigger garage, so I'm going to tear down their garage and build a great big garage, what's wrong with that?
Well, it depends. It depends on it depends on whether you can do that or not. Sometimes if there's property on the if the owner is can get a building permit to build the garage, then they can do it. If they don't, then they may not be able to.
Yes, I think he hid the facts there to try and find out what you thought. Okay, we're going to go to Russellville. Hey, Ollie, thanks for giving us a call tonight. What can we help you with?
Oh, yes. I was calling to find out more or less how long do you think it takes for a person to get a wrongful death lawsuit for a nursing home?
Yeah. So basically, in a situation where you're looking at a claim against a skilled nursing facility, nursing home, assisted living facility, you have 2 years from the date of the death of the person, of the decedent, in order to file a wrongful death claim. So you have to have it filed, complaint in the courthouse within 2 years. Now, the person that has the authority to file that claim is the personal representative of the estate. So if somebody has a will that designates a personal representative, then that person would be the person that you'd have to have appointed through the probate court. If the person doesn't have a will, then you go to the probate court and you ask somebody to appoint a personal representative. The spouse, the family member has priority for a certain period of time, and then after that time, then anybody can serve as personal representative. The personal representative is not necessarily the person that would take the proceeds of any wrongful death claim. In Alabama, money recovered for wrongful death is divided according to the laws that are in place if you don't have a will. So it's the spouse, the children, it could be the parents, depending upon the circumstances.
Now, you said 2 years.
Sure.
You have a Tennessee license
Correct.
as well as
Yes,
an Alabama
absolutely.
one.
Yeah.
Is it different up there?
Yes, absolutely. So he was in Russellville. So Alabama has a 2-year statute of limitations. Tennessee has a 1-year statute of limitations for personal injury, wrongful death claims. So that's something you really have to kind of look out for, make sure where the act occurred.
Well, now, we want your calls, so give us a call. We want to give you some answers here. We'll be back in just a minute.
writes your calls live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League and Brooks. Featuring the knowledge and experience of attorney Michael Timberlake, attorney Will League, attorney Heath Brooks, attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Give us a call. But you all have been doing some Halloween stuff around the office.
Yeah, every year we tend to, in the spirit of the holiday, we tend to, have a little bit of a contest.
Is that an ostrich?
We think it's the emu from Liberty Mutual. And then, and we have Mrs. Doubtfire, who was always
just as I would expect.
And the Oompa Loompas and the other Wonka folks were here, and that is our dog Ruby, and she was a showgirl. And that's our judge, my neighbor, and our office manager.
Oh, very nice.
We really enjoyed the bat. That was a really, really nice costume. So we always have a good time. And William Maservi dressed up as the Brawny Man. I don't know if really had to dress up. And Captain Morgan was there to
Excellent.
Provide some joy.
Well, it seems like you're all having a very good time.
Well, we tend to have a good time, and we really enjoy the a little camaraderie. Yeah. Oh, and that was our judge.
Well, I see the judge is taking some payola there.
Yeah, he was taking bribes.
Well, Lynn from Scottsboro has been very patient to wait while we go through all of that. Lynn, what can we do for you?
Yes, sir. I have 2 questions, but pertaining to the same thing. First of all, I need to know what the law is on how to get a renter out of a house.
Ooh, how to get a renter out of a house. Basically, there's a Landlord-Tenant Act in Alabama, and it requires that you provide notice of eviction, and I think there's a 14-day period for that person to get out. Once you provided the notice of eviction, then you can go to the sheriff, and the sheriff will go to the door and then put something on the door saying, you have had to get out, and then I think they have another 14 days from that point. So it roughly takes about a month. But if you can go online, you can look at the Alabama Landlord-Tenant Act. There's, it's all over the place. So that's kind of the process that you have to do to evict somebody in Alabama.
Okay, you wouldn't be calling for King Charles, and he's trying to evict someone here.
Oh, Charles evicted his brother, didn't he?
That's right, indeed.
And put him in a nice little house, though, I think.
But now you said you had a second question. What's that?
Second question is, okay, without saying any names, what about the people's property, them not giving the people enough time to get their property out, like the children's stuff out? Like, they were there still getting the children's stuff out, made them leave, and the children did not get their furniture, their toys, is there not something that you can do about that?
Well, there's a certain time that you have to allow somebody for eviction. And then, in terms of their belongings, I think that's the, they have an obligation to get that, their belongings out within that same time period. I'm trying to remember if there's some loophole there about they can't just set it on the curb. But, honestly, I don't know. But I think it's still, within those time periods, it would be not only the person, but the person's belongings would have to be off the premises.
Well, Jerry from Newmarket is also on the line. Hey, Jerry, how's it going?
Pretty good.
What's on your mind?
Yes, I was wondering about, I had laser surgery, and it kind of messed my eye up, and I can't see as good now as I could before. And I was wondering what could I have done to get my eyes straightened back up.
Right. Well, so basically it's a claim under the, potential claim under the Alabama Medical Liability Act. This is a special act that protects doctors, nurses, hospitals in this situation where somebody has an injury as a result of medical care. You have to prove that the doctor did something that no reasonable doctor would do under the same circumstances, and you have to prove that that substandard care was the direct cause of the problem that you have. The jury in these cases is specifically instructed that simply because there was a bad outcome, because something happened that we didn't want to happen, or that your vision wasn't as good as they thought it was going to be, or could be worse than it was when you went in, the jury can't presume that the doctor did something wrong because of that. You have to have an expert come in and explain what the doctor did wrong. So the mere fact that you've got an injury in a medical situation doesn't mean that you have a claim against the doctor. You have to prove that the doctor did something, was at fault in some way. And if it is a known complication of a procedure, if it is something that can happen, known risk, known complication of a procedure, can happen when the doctor does everything they're supposed to do, then a lot of times there's no way to recover in that situation, even if you're injured. It's crazy.
It is crazy.
Mm-hmm.
We've got an email question sort of back on the holiday theme, if you
Right.
don't mind. It says, I love Halloween. If you scared someone so bad that they ran away and ended up falling and hurting themselves somehow, could you be sued for that?
I think that would probably just go into the things happen category. If you push somebody down, that's a battery or an assault. If you, I was talking to somebody the other day about a dog that got out and was unleashed and knocked somebody down in a garage, and we were like, well, the dog didn't bite anybody, but the dog was in a place it shouldn't have been, so that's a claim.
Listen, we have a new law that's just going into effect here in November in Alabama, and it has to do with the age of a child and what they could do medically, right?
Sure. Yeah, previously, a child that was 14 years old or older could make a decision about their medical care. They didn't need parental consent or parental guidance in order to make decisions about their own medical care. The legislature, in their infinite wisdom, decided that that's too young, and now they have increased it to the age of 16 years old. So children that are 16 years old or greater are going to be able to make their own decisions about their health care. Anybody below that is beholden to their parents or their guardians for consent to make those decisions.
So for you to get medical records now, you've got to go, a 15-year-old,
right?
You would have to go to the parents, where you used to just go to the child.
Yeah, what we used to have to, the thing that we did is when we sign a medical authorization form, anybody that was 14 years or older had to sign the form themselves if it was a child, not just the parent. Now it's going to be 16 years or older.
Excellent.
Well,
I'm trying to see what else we got here.
Well, anything going on with it?
Let's see. Who's been talking to us? Also, you can watch us on the Facebook page for WAAY TV. Mm-hmm. So if you're having trouble getting us over the air, you can go to Facebook anywhere in the world.
Yeah, we did not broadcast SEC games, but we do have Facebook Live. So if you want to watch the show and you're not able to because of the dispute going on, we have it on Facebook Live. It's also on. We also posted on WAAY's website on their news site after the show. So it's available to watch for people that they're unable to access it normally.
Now, I didn't hear the person's name, but we've got a call from Hartselle. Andrew from Hartselle. Hey, Andrew.
Hey.
Hey, what's on your mind tonight?
I'm trying to find out, does anybody else pay hurricane insurance that lives in Hartselle?
Is anybody that lives in Hartselle that does what? I'm sorry?
Pay hurricane insurance.
Hurricane insurance.
Oh, space. Does anybody offer hurricane or pay for hurricane insurance?
$9 a month for it.
Right. Okay, I got you. You can insure yourself for anything you want to insure yourself for. For a long time we talked about earthquake insurance in Alabama and whether that was something you would need. You may not need that in Alabama, but the more that Mother Nature gets unpredictable, the more you may want that. Same thing with hurricane insurance. If you look at what happened with the storm that came through and went into North Carolina, it did cause a lot of damage. But typically, hurricane insurance is something that is specific to a coastline. In Alabama, off the coastline, And even, in some carriers on the coastline would define it as coverage for wind damage and then water damage. So which is, what would be made up of a hurricane damage. So it's not necessarily hurricane specific coverage, but you're going to want to insure your property for wind damage, regardless of whether it's a hurricane or tornado or whatever, and water damage, because if it's a thunderstorm or any kind of major storm that causes damage to your property. So it's going to be covered, and it's probably something you want to include. If it specifically says hurricane, you may want to exclude it, but you also think about, there's a hurricane that came all the way through North Carolina and did a whole lot of damage, so you may want to consider that.
Well, but you fought insurance companies a lot because of roof damage and any advice?
Yeah, I mean, it's, the policies are real specific. We get in a lot of situations where people don't understand what they have purchased, and because they may have gone online or whatever. It is not, they're different kind of homeowners coverage. Every carrier's got a different coverage. It helps to have an agent explain to you what the coverages are, what your options are. Is it replacement coverage, which means they would pay the cost of replacing a structure, or is it the actual cash value, which is the value of the structure on the property, which can be not a lot in situations.
Well, you often talk about uninsured motorist coverage.
Right.
You still a big supporter? That
yeah, I mean, in automobile insurance, this is one of the things that I would say is it's very important that you consider underinsured, uninsured motorist coverage. And basically, it's coverage for your automobile that protects you and the occupants of your vehicle in the event that you are hit by somebody that doesn't have insurance or doesn't have enough insurance. The mandatory minimums in Alabama are $25,000. So even somebody's got liability coverage may not have enough to pay for any significant damage. This coverage that you purchase, the insurance company has to offer it, but they only have to offer it in $25,000 per vehicle amounts. You can go up with that. So I would encourage you to ask your insurance company about underinsured, uninsured motorist coverage and select an amount as large as you can afford, because that's the coverage that protects you and the people in your vehicle.
Excellent. Stick with us. We'll be right back. Tonight, you can reach Michael Timberlake at Timberlake League and Brooks right here in Huntsville, 256-536-0770. They also have an 800 number, or just catch them on the web at law-injury.com.
And Sharon Doviet will be back next week, 256-539-7337. Sharon does family law in Huntsville, which is divorce, child custody, that kind of thing.
And you appear usually, or often, someone from the firm does at noon.
Yeah,
Here
noon
on-
tomorrow. We do an abbreviated version of this. We take 3 to 4 calls right before noon every Monday on 31.
So you take phone calls there also.
Yeah, phone
that's
calls,
great.
texts, it's all good.
Good. So if you need, we did get a message tonight, said, like your show, and we appreciate that. Thank you very much. And I hope I never have to use you.
Well, that's, I tell a lot of my friends that. They say, look, we're a personal injury law firm. So if you're coming to see me, something bad's happened to you, you don't want me to be your lawyer. But if you need me, I'm here.
God bless America. All right. Well, listen, thank you so very much for joining us. We'll see you next week, same time, same TV station.